However, what the government is proposing is the wholesale abolition and replacement of the AAT, and this creates significant transitional challenges, such as transferring a large existing caseload, the rollout of new systems, and dealing with staff turnover and recruitment lags. So these challenges may in fact lead to additional and unintended delays.
The member for Hughes.
Thank you, Deputy Speaker. I rise to speak on the Administrative Review Tribunal Bills of 2023. And at the outset, Deputy Speaker, these bills are now the subject of a Senate committee review, and I would say that in the circumstances it would be most appropriate that they are dealt with following the Senate's consideration, and I say that also as a member of the House Standing Committee on Social Policy and Legal Affairs, which also had a very brief window of opportunity to look at this legislation during the Christmas period. But, Deputy Speaker, if we can turn to a more fundamental aspect of this legislation, and that is this. A robust administrative law jurisdiction is absolutely pivotal to Australian democracy. It ensures accountability and transparency in government decision-making processes. And by providing avenues for judicial review of administrative decisions, it upholds the principles of legality, ensuring that government agencies act within their legal authority and in accordance with established laws. Deputy Speaker, administrative review is the process by which a person or a body, other than the primary decision-maker, reconsiders the facts, laws and policy aspects of the original decision and determines the correct and preferable decision. It can be considered to be the idea is that the new decision-maker steps in the shoes of the original the primary decision-maker. And so it's a review on the merits of a decision rather than so much a legal challenge. But if the reviewer considers that the original decision was not the correct and preferable decision, they can then step into the shoes, as I've said, and substitute their decision for the original decision. And, Deputy Speaker, in this way, this strengthens the rule of law by fostering public trust in the fairness and integrity of governmental actions, ultimately safeguarding the democratic rights and freedoms of Australian citizens. Under our common law system, any Australian citizen or person with the appropriate standing, in a legal sense, may seek judicial review of administrative action by decision-makers. So this is the administrative law process we have in our country is an opportunity for a merits review of administrative action that is fair, just, economical, informal and quick, or that is the way that the AAT was initially established. And, Deputy Speaker, I believe strongly in the rule of law, and I do believe strongly in a robust administrative law system. And I think that the AAT, having now been in existence for several decades, reform may be warranted, but the overall merits of these changes are questionable. Since 2015, for example, the AAT has experienced a significant spike in the number of lodgements of cases. It's increased from 41,400 in 2015-16 to a peak of 60,595 in the years 2018 to 2019. And this spike has been driven by a range of factors, including the legacy caseload that arose from Labor's unauthorised maritime arrivals. In addition, the amalgamation of different tribunals into the AAT in 2015 created legacy issues, such as different systems and processes operating in parallel with different parts of the tribunal. And these are certainly issues, Deputy Speaker, that I say do warrant scrutiny and reform. However, what the government is proposing is the wholesale abolition and replacement of the AAT, and this creates significant transitional challenges, such as transferring a large existing caseload, the rollout of new systems and dealing with staff turnover and recruitment lags. So these challenges may in fact lead to additional and unintended delays. It remains to be seen whether the legally significant changes, particularly in the migration space, will drive further lodgements or lead to a further spike in litigation. So because the systematic and downstream impacts of these changes are unclear, it is therefore, while it might be appropriate that there is a system of review, the AAT is one part of a complex system, and changes to one part of this system could well affect various others with unintended consequences. The reforms in the bills, as proposed by the Attorney-General and the Government, only address one part of the system, and it is again unclear what those unintended consequences may be. And just by way of example, Deputy Speaker, to explain that proposition, if the AAT, for example, was to significantly increase the rate at which it processed reviews of visa refusals, for example, it is almost inevitable that the federal courts would then be hit with a wave of judicial review applications. And these broader impacts should be considered as part of a committee inquiry, and that is why I say that is only one reason that I say that it is appropriate that this is first of all dealt with by the committee, by the Senate committee. And if we can go back, Deputy Speaker, just to look at the purpose, the stated purpose of this bill, it's to establish the Administrative Review Tribunal to replace the Administrative Appeals Tribunal. And the new bill sets out 11 different provisions or parts that relates to the new proposed tribunal's membership, structure, review procedures and various other matters. And, Deputy Speaker, the legislation, the proposed legislation, also re-establishes a body known as the Administrative Review Council that makes consequential and also makes consequential amendments to a number of Commonwealth Acts. And as I said, Deputy Speaker, all these three bills have been referred to the Senate Legal and Constitutional Affairs Legislation Committee for both inquiry and report by the 24th of July 2024. And, Deputy Speaker, by way of further background, the AAT and the entire Commonwealth Administrative Review System was initially lauded as an innovative model of tribunal reform, but over time it's faced an ever-increasing range of challenges. And we have, since the 80s, in fact, had numerous inquiries, government reports that have documented these challenges and recommended a series of major reforms. Some of those major reform recommendations have been picked up by successive governments and others have not. But essentially, the problems and failures of the AAT appear to have risen as a result of the proliferation of specialist merit reviews tribunal and the subsequent attempts at amalgamating these separate bodies into a single unified tribunal, which was the original intention of the legislation. And, Deputy Speaker, of course, with this there have also been significant resourcing pressures with a corresponding dramatic rise in the matters being reviewed, resulting in enormous backlogs preventing the timely and final resolution of matters. And these problems have been particularly evident in migration and review matters, where the delays are enormous and therefore unfair and certainly need to be addressed. So there are overall 11 parts to the way that the bills are structured that deal with all of the things such as their powers and proceedings, membership and structure, any special tribunal procedures, and particularly processes in intelligence and security matters. But as a background overall to the Australian merit review system, the foundations of our merit review system were laid, as I said before, in the mid-1970s, and the AAT commenced operation on the 1st of July 1976, and it's probably appropriate to look briefly at the legislative framework under which the AAT currently operates. And it is the Commonwealth's largest tribunal, both in terms of membership and also in terms of its scope to hear cases. The AAT when initially established, it was stated that it should be the Merits Review Tribunal for all Commonwealth administrative decisions, unless specific policy considerations support review conducted by an alternate body. And as I said, one of the issues that have been highlighted by successive reviews and inquiries has been the proliferation of other tribunals, which has led to unintended consequences within the AAT. Presently, the AAT members consist of a president, who must be a federal court judge, and various members known as deputy presidents and senior members, as well as members. It currently has a workload of 9 divisions, which covers areas of Commonwealth decision-making, which include migration, the NDIS, freedom of information, taxation, and some other miscellaneous Commonwealth legislation. As I've said, the challenges that really face the AAT as present is that it is beset by delays, dramatic increases in workload, and an extraordinarily large backlog of applications. And these problems have been particularly highlighted in the Migration and Refugee Division, where in the latest figures confirm that in the 2020 to 2021 year, the percentage of cases finalised within 12 months was 20%. So clearly, more than 80% of cases are taking more than 1 year to conclude, and that is not a just and fair outcome. So there have been a number of concerns raised by various bodies and stakeholders about these figures. The Law Council in particular has said that the need to increase the number and timeliness of decisions, as well as to increase the number of appropriately qualified and experienced members, particularly in the Migration and Refugee Division and other divisions. The New South Wales Bar Association took the view that AAT members should have a sufficient level of competence to make the, quote, correct or preferable administrative decision. It also, the Bar Association, described the negative impacts that cascaded from members lacking relevant expertise. So while there are certainly some changes that have been highlighted by specialist bodies and sectors, it is still not clear as to why the Attorney General is suggesting that the entire AAT regime in fact be ripped up and a new body put in its place. The other major change within this legislation is the re-establishment of a body called the Administrative Review Council, and its task being to monitor and provide advice to the government in relation to Commonwealth administrative review. Now, whether that is just a symptom of a desire for larger government, or whether that is a body that will in fact provide sound advice and will be an important part of the administrative law regime, remains to be seen. And as I said, I think we should wait to hear what the Senate inquiry has to say about that. Deputy Speaker, I sat on the House of Representatives Standing Committee on Social Policy and Legal Affairs. We adopted an inquiry into this legislation on the 14th of December 2023, and we were required to present the report for the Attorney General in February 2024. That is, of course, right over the Christmas period. And although the recommendations of the committee overall were that the legislation be supported, the coalition comments on that were that while we did not provide dissenting comments, we really believe, and the other coalition members were the member for Menzies and Mr. Pat Conahan. Mr. Conahan. But we said that we strongly believe that such a large change to Australia's system of administrative appeals needs an inquiry where stakeholders from across the board are given ample opportunity to express their views, and that was in the context of only 1 day of a public hearing into what is a significant change to our whole system of administrative law. So therefore, Deputy Speaker, to conclude, administrative law is an important tenet of our legal system, but based on the current delays and backlog of cases, it is appropriate that consideration is given to the way that the tribunal functions. However, it is unclear why this legislation is being why it was rammed through a House committee process and why it is now being rammed through Parliament when in fact it has been referred to a Senate inquiry. So I would say that the most appropriate thing is to wait until July and consider the comments from the Senate inquiry. Thank you, Deputy.
Thank you.